Good morning, friends. In the continuation of AIBE exam previous question papers, we'll be discussing about alternate dispute redressal, including Arbitration Act. 4 questions are expected from this topic. Okay. An arbitration proceeding is a quasi-judicial proceedings. Arbitration is a quasi-judicial proceedings. What is ad hoc arbitration? Ad hoc arbitration is a proceeding administered by the parties themselves with rules created solely for the specific case, and parties make their own arrangements with respect to all aspects of the arbitration, including the rules and laws. And the seal of administration or arbitration, the language, scope, issues will be resolved by means of the arbitration. That is the ad hoc arbitration. Reference to the arbitration is provided under section 8 of the Arbitration and Conciliation Act. The section of the Arbitration and Conciliation Act dealing with the time of the commencement of the arbitration proceedings is 21. Section 21 talks about the Arbitration and Conciliation Act dealing with the time of the commencement of the arbitration. Section 21. Unilateral model law and rules do not become part of Arbitration Act so as to become in an aid to construe the provisions of the Act. This is the case with respect to the Union of India versus East Coast Boat Builders Engineers. This is one of the landmark case in case of the arbitration. According to section 7(4) of the Arbitration and Conciliation Act, an arbitration agreement is in writing if it is contained in a document signed by the parties, exchange of the letters, telex, telegram, any other means of telecommunication, exchange of the statements of the claims to defend, in which the existence of the agreement is allegedly by one party and not defended by other party. All of this. Waiver of the right to object the deviation from the arbitration agreement is mentioned under the section 4 of the Arbitration Act. Arbitration Act 1996 repeals the Act of Arbitration 1940, Arbitration Protocols and Convention Act 1937, and Foreign Awards Recognition and Enforcement Act 1961. All these acts are repealed by Arbitration Act 1996. BATNA, BATNA stands for Best Alternate to a Negotiated Agreement. Section 9 of the Arbitration Act deals with the interim measures by the court. Section 9 talks about the interim measures by the court. In which of the following cases Supreme Court held that an international commercial arbitration is one which has its jurisdiction or a legal seat of arbitration outside the India? Bhatia International versus bulk trading. The answer. Which one is a foreign award? Any award passed in foreign seated arbitration is a foreign award. What is the maximum duration within which a fast track arbitration must be completed? 6 months is the maximum period for a fast track arbitration. Which among the following is not an ADR method under section 89 of CPC 1908? 89 of CPC deals with the ADR, but mini trial is not a part of the ADR. What is the maximum number of conciliation allowed in a conciliation proceedings? There is no such a maximum. So none of the above is the answer. What is the status of settlement agreement in conciliation proceedings? It is same as a settlement award. The Indian legal system has evolved a new technique of alternate dispute resolution which is popularly known as Lok Adalat. It owes its origin to the Legal Services Authority Act 1987. Lok Adalat is due to the Legal Services Authority Act 1987. Which of the following is an innovative form of an alternative dispute redressal mechanism? Lok Adalat is one of the innovative form of ADR. Part 3 of the Arbitration and Conciliation Act 1986 formalizes the process of the conciliation. Part 1 is domestic, Part 2 is the foreign awards, Part 3 is the process of conciliation. Section 22B of Legal Service Authority Act empowers the central or a state authority, abolish the local, works for the local, power of the local, Lok Adalat or a permanent Lok Adalat, none of the above. None of the above is the answer. The language which is to be used in the arbitration proceedings is decided by the parties mutually deciding. The arbitral proceeding shall stand terminated on making the final award or by an order of the arbitration tribunal or by when the parties agreed to the particular dispute for terminate. All of these are the reason to terminate the arbitration process. Every award of the Lok Adalat is deemed to be a decree of a civil court. The Arbitration and Conciliation Act 1996, Section 18 to 27 states the conduct of the arbitral proceedings. Section 18 to 27 talks about the conduct of the arbitral proceedings. The objective of the European Union Directive on the Media is to ensure the better access to alternate dispute resolution in cross-border commercial conflicts. In most EU member countries, which of the following is most visible form of ADR? That is the arbitration. Part 3 Arbitration and Conciliation Act deals with the process of the conciliation. The conciliation proceedings cannot be used as evidence in any judicial or arbitration proceedings. Which is the incorrect statement. An arbitral award is a contract is not a correct statement. Arbitral must be in writing and signed is correct. Arbitral award is included in interim award is also correct. Arbitral award is not a contract. The present Arbitration and Conciliation Act 96 is based on the model of the unisetral. The provision of the Arbitration and Conciliation Act 1996 have to be interpreted being uninfluenced by the principles underlying the 1940 Act. This observation was laid down in the case of Sundaram Finance versus NEPC Limited. The judgment in the case of ONGC versus SAW Pipes skews the delicate balance carefully crafted by the model law. Supreme Court, in case of a TDM infrastructure versus UE development, held that irrespective where the central management and control is exercised by a company, companies incorporated in India cannot choose a foreign law as a governing law. Which section of 1996 Arbitration Act permits the parties to engage in a conciliation process even while the arbitration proceedings are on? Section 30 allows the parties to go for a conciliation while doing the arbitration process. Amendments made in the year 1999 and 18 through the insertion of a section 89 to the Civil Procedure Code introduced the provisions to enable the courts to refer to the pending cases to the arbitration, conciliation and mediation to facilitate early amicable solution. Section 89 of CPC was incorporated by the Amendment Act 1999. in which case the Supreme Court held that Part 1 of the Arbitration and Conciliation Act would equally apply to the international commercial arbitration held outside the India unless any or all of the provisions have been excluded by the agreement between the parties. In case of a Bhatia International versus bulk trading. Establishment of a permanent Lok Adalat is envisaged under the section 22B of the Legal Service Authorities Act. 22B of the Legal Service Authority Act establishes the permanent Lok Adalat. In which year an amendment to the code of CPC has been included? 2002. Under the Arbitration and Conciliation Act, an arbitration clause is in a contract or in the form of a separate agreement. A decision by the arbitral tribunal that the contract is null and void shall not entail ipso jure the invalidity of the arbitration clause. The arbitral tribunal shall not be bound by CPC 1908 of the Indian Evidence Act. CPC and Indian Evidence Act arbitration need not to take these two acts. Negotiation is the process by which interested parties resolve the disputes agreed upon the course of action, bargain for an individual or a collective advantage, or attempt to craft the outcome which will serve the mutual interest. That process is the negotiation. The commencement of the arbitral proceedings is not depending on the interim relief being given or denied under Section 9 of the Arbitration Act. This is held in case of firm Ashok Traders and others versus Gurumukh Saluja and others. Which provision of the Hindu Marriage Act 1955 deals with the conciliation? Section 23(2) of Hindu Marriage Act deals with the conciliation. Which section under CPC deals with the settlement under ADR? Section 89. Indian Civil Council for the Arbitration was established in 1996. Lex arbitri means arbitral tribunal sitting in India can apply the law of Singapore. Lex arbitri, they can apply sitting in India for law of Singapore. In India, Contract Arbitration and Civil Conciliation Act is established in 1996. Section 10(1) of the Arbitration and Conciliation Act talks about the number of arbitrators. Number of arbitrators should be either 3, 5, 7. It should be something odd numbers. So section 10(1) or 10(I) speaks about the number of arbitration. Friends, this is about the Arbitration Act. Now we will be discussing the administrative law. About 2 to 3 questions are asked from this. What is meant by the procedural ultra vires? Ultra vires means it is a non-observance of the procedural norms by the rule-making authority, and it may make the rule ultra vires due to non-observance of the rule by making the authority. Hence, they are void. The ground of error of law apparent on the face of the record is connected with certiorari. One of the writ certiorari deals with the ground error of the law apparent in the face of the record. Parliament may by law establish administrative tribunal under the Article 323A of the Constitution. 323A of the Constitution deals with the establishment of the administrative tribunals. In the case AK Kraipak versus Union of India, related to the likelihood of the bias. Judicial control of delegated legislation may be exercised under the grounds of doctrine of ultravirus, modified exclusion of the judicial review. Judicial control of the delegated legislation may be exercised on the grounds of the doctrine of ultravirus, modified or exclusion of judicial, all of these. Which of the following courts, tribunals cannot entertain a public interested litigation? Administrative tribunals cannot entertain the public interested litigation, Central Administrative Tribunal. Delegated legislation was declared constitutional in case of a Re Delhi Laws Act case. The provision of the Administrative Tribunal was added by the 42nd Amendment with Article 323A. 42nd Amendment 323A article for the Administrative Tribunal. Droit administration is a system of French administration system. Droit is a French system. The word ombudsman is derived from the Swedish administration. Ombudsman from the Swedish administration. Section 3 of the Commission of the Inquiry Act 1952. The Inquiry Commission is appointed by the central government or a state government. Section 3 of the Commission of the Inquiry Act 1952. Inquiry Commission is appointed by central government or state government. It refers to the authority derived from the official character merely, not expressly conferred upon the individual character, but rather than the annexed to the official position. This is called the ex officio. By being in the chair, they get the authority, ex officio. The term sabbatical is connected to the paid leave for study. Sabbatical is a paid leave for the study. In case in which a specific act confers to the discretionary powers on authority, the court can direct the manner in which the power exercised, or court can direct the power be exercised in according to law. These are the situations where the specific act confers the discretionary power on an authority. Which of the following statements hold true for the adjudicatory bodies? Inherent lack of jurisdiction in a tribunal cannot be cured or created by act of the parties. The requirements to give the reasons in administrative decisions which affect rights and liabilities has been held to be mandatory by the Supreme Court in case of S.N. Mukherjee versus Union of India. State of Karnataka versus Union of India, AR 1978. Appointment of the Commission by the Union Government under Section 3(1) of the Commission of the Inquiry Act 1952 to look into the charges of the corruption against the Chief Minister and other ministers of the state was challenged in the case of S.N. Mukherjee. A federal structure is not jeopardized. The case versus Karnataka versus Union of India was challenged with the federal structure is not jeopardized. Constitution of India has recognized the arbitration tribunals, the inquiry tribunals as the instruments as a quasi-judicial administration is Section 323A and 323B. That is the establishment of the tribunals with the amendment 1976, 42nd amendment of the Constitution recognizes or establishes the tribunals, administrative tribunals under the Article 323A and 323B. Nemo judex in causa sua means no man shall judge in his own case. First time it was given by the Lord Coke in Dr. Benham's case. The writ of the certiorari is issued against the lower courts or a quasi-judicial bodies. Audi alter partem means hear the other side. Second Administrative Reforms Commission constituted on 31st August 2005. If a quasi-judicial authority violates the principles of the natural justice, the appropriate rate is a certiorari. The delegatus non-protest delegate means a delegate cannot further delegate. A delegation non-protest delegate means a delegate cannot further delegate. Friends, these are all with respect to the administrative tribunal. We can expect at least 1 or 2 questions. Now the 2 questions expected from the company law. Section 8 of the Companies Act 2013 contains the provision related to the formation of the companies with the charitable objects. Section 8, formation of the companies with the charitable objects. Verification of the registered office shall be within 30 days of the incorporation has to be done. Minimum numbers of the directors in the public company is 3. An associate company in relation to the another company means a company in which that other company has a significant influence but which is not a subsidiary of the company having such an influence and include a joint venture of the company. Associated company is neither a subsidiary nor joint venture, but it has a proper influence in the main company. Which court or authority has the power to punish any person for the contempt of the National Company Law Tribunal? That is, the National Company Law Tribunal has the authority. It deals with the internal management of the affairs. Articles of the association deals with the internal management. A memorandum of articles deals with the company, including external. Article of association is internal. The prospectus which does not include complete particulars of the quantum or a price of the securities include red herring prospects. Red herring prospects means prospects which does not include the complete particulars of the quantum or a price of the securities but includes the main important points. When there is no profit in 1 year or the profit of the company is not enough to be paid fixed dividend on a preference shares, the areas of the dividends are to be carried forward and paid before cumulative preference shares. Articles of the company can be altered by shareholders by passing a special resolution. Under the Company Act, every person subscribing to the memorandum of a company must take at least 1 share. Minimum number of persons required to incorporate a public company is 7. A private company can commence business by certification of incorporation. What is the maximum number of the partners? In a banking business, 10 are the maximum members. And minimum members required for incorporation of the in public limited is 7. A does not fall under the clause of the memorandum of association. That means the director is not falling under the memorandum of association. The serious fraud investigation takes up the case for investigation referred to by central government. How is the net worth of a foreign company calculated for the purpose of the corporate social responsibility (CSR)? As per the section 198 and section 381 of the Company Act, section 198 and 381 of Companies Act, corporate social responsibilities is calculated. Which of the following actions can be taken up by registrar under section 4.5 of the Companies Act? Registrar can take action for striking of the names of the companies from the register of companies under section 4.5 of the Companies Act. Which of the following companies will have to constitute corporate social responsibility as per the Companies Act 2013? A company having a net profit of 5 crores or more, or net worth of 500 crores and a turnover of 1000 crores or more need to take the corporate social responsibility. Who among the following is authorized to issue the regulations regarding the shelf prospectus? SEBI is authorized. Which of the following services cannot be provided to the company by an auditor appointed under the provisions of the Company Act? Cannot be provided. Internal audit, actuarial audits, managerial services, all of them. All of them cannot provide the company by an auditor appointed by the Act. Provisions regarding the corporate social responsibilities are incorporated under the section 135, while the section 198 and 381 calls for the calculation, whereas the provision is provided under 2013 Act, section 135. Which is the corporate social responsibility? Project-based protection of the national heritage is one of the corporate social responsibility. Company Act 1956 accord recognition only to account standards, whereas section 27 of the Company Act 2013, the recognition is accorded to both accounting as well as auditing standards. Section 27 of Companies Act 2013 accord both auditing and accounting standards. Company Act 2013 allows the transformation of one-person company also. Section 26 of the Companies Act requires disclosure of the prospectus and names of the address of the CFO about the sources of the promoter's contribution, among others. Sources of the promoter's contribution should be disclosed under Section 26 of the Companies Act. Section 253 of the Company Act deals with the determination of the sickness. 253 deals with the determination of the sickness. Under Companies Act, any company having a net profit of the 500 crores more or 5 crores net profit or 1000 crores turnover need to pay 2% of their profits for the corporate social responsibility. Under section 135 corporate social responsibility, 2% of the company whose net worth is 5 crores or more or whose turnover is more than 1000 crores or whose company net worth is 500 crores. OECD guidelines constitution one of the most important CSR tool available for the company. OECD. 2013 Company Act increased the limit of the number of private companies from 50 to 200. The standards of the auditing have been accorded legal sanctity in the 2013 Act, subjected to notification of NFRA, National Financial Regulation Act. SFIO stands for Serious Fraud Investigation Office. SFIO is a Serious Investigation Fraud. Which provisions of the Companies Act discusses about the issue of the bonus shares? Section 63 discusses the issue of the bonus shares. Which of the following is a ground for recognition for the automatic adjournment of the general meeting? Quorum of the meeting, if it is not present, automatically adjournment can happen. Which of the following meetings can be called by the members? Extraordinary general meeting can be called by the members. Which of the following powers cannot be exercised by the board of directors without holding the meeting? Power to adopt additional director cannot be taken without having the meeting. Which of the following is not ground for the compulsory winding up a company? Non-holding of an annual general meeting need not be a ground for the compulsory winding of a company. Trading activities of a company were stopped temporarily in view of the trade depression with an intention to continue the same when the conditions improve. A petition was preferred into the tribunal for winding up the company is liable to be dismissed when there is an opportunity due to the conditions that temporarily it is stopped for the trade depression, it cannot be wound up. Amalgamation of the companies in the national interest is dealt under the section 396 of the Companies Act. 396 speaks about the amalgamation of the companies. Under section 171 of the Companies Act, a company may be called by giving 21 days notice in writing. That is a minimum 21 days in writing. Then the meeting can be called. This is a notice for the general meeting. A private limited company limits the number of the members to 40. Upon failure to hold a statutory meeting, the penalty for the defrauding company shall be 500 per day or wound up or 1000 per day. None of these are applicable. Free transferability of the shares is mandatory as a public limited company. Memorandum of Association is listed under the Table B of the Act. Which of the following clauses from the Memorandum of Association cannot be amended? The registered office clause cannot be amended through the Memorandum of Association. Friends, there are two questions expected from the environmental law. Let us also go through these questions and answers. Basel Convention is associated with control of the transboundary movement of the hazardous waste and their disposal, one country to other country sending the disposals. Basel Convention is associated. In which of the following case the Supreme Court first of all made an attempt to look into the question regarding the extension of the right to life to the right to the health and other hygienic conditions? It is a Rural Litigation and Entertainment Kendra versus State of Uttar Pradesh, where the environment is also the one of the right to the life. According to Environmental Protection Act 1986, any solid or a liquid gaseous substance present in such a way as may be or tend to be injurious to environment is not permitted. NGT, National Green Tribunal, cannot exercise its jurisdiction over the Wildlife Protection Act or a Scheduled Tribe and other Traditional Forest Dweller Recognition Act. Public Liability Insurance Act was enacted in 1991. Environmental Impact Assessment EIA is mandatory under Environmental Protection Act. Which of the following appears to contribute to global cooling rather than the global warming? Aerosols contribute to the global cooling. Convention on a Climate Change was the outcome of the Rio de Janeiro Conference, World Global Environmental Conference, Rio de Janeiro Conference. The Coastal Regulation Zone notification was issued in 1991. Coastal Regulation Zone notification was issued in 1991. The case of the Krishna Gopal versus State of MP is related to the noise and air pollution. Within the purview of the Water Act, meaning the stream is defined as includes a river, a water course or a subterranean river. The leading case on the environmental is the MC Mehta versus Union of India, Sriram Fertilizers case. Environmental Protection Act 86 was enforced on 19th November 1986. Which of the following is a function of the Central Pollution Board under the provisions of section 16 of the Prevention of Controlling Act, that is to improve the quality of the air? The destruction of the fish by use of explosives or a poisoning is prohibited under the Indian Fisheries Act 1897. Which of the following is not included in the definition of the cattle as given in the Indian Forest Act? Kitten is not included. Under the Wildlife Protection Act 1972, The Water Prevention and Controlling Pollution Act 1974 regulates the discharge of the hazardous pollution into the nation's surface act. That is the 1974 Prevention of the Control Pollution Act. It was held by the Supreme Court that noise pollution beyond the permissible limits cannot be tolerated in the case of the Church of the God in India versus KKR Majestic Colony Welfare Association, where the sound pollution cannot be tolerated. According to Environmental Protection Act, any solid, liquid or a gaseous substance present in such a concentration may be or tend to be injurious to environment is covered under the environmental pollutant. National Conservation Strategy and Policy Statement on Environment and Development is a major policy taken in 1992. Section 2A of the Environmental Protection Act defines the environment. 2A defines the environment. Polluter pays principle means polluter should bear the cost of the pollution as a polluter responsible for the pollution. Pollution is a civil wrong. By its very nature, it is a tort committed against the community as a whole. A person, therefore, who is guilty of causing pollution has to pay the damages. This is observed in the case of a MC Mehta versus Kamalnath. Polluter pays the cost. India became a party to the International Convention on Biological Diversity in 1994. These are the few questions on environmental, and few more questions with respect to the cyber law we'll be discussing now. One or two questions can be asked. Cyber crime is intangible in nature. Intangible means there is no direct material or a body. That is intangible. You cannot touch, you can only feel. Cyber law deals with all activities concerned with the internet, IP or e-commerce. All are covered under the cyber law. Section 66A of the Information Technology Act held unconstitutional in case of a Shreya Singhal versus Union of India, where she made a posting in Facebook with respect to the demise of Balachandra Thackeray. Possession of Balachandra Thackeray. She made a comment and there was a case filed against her, arrested. Then the Supreme Court held that Section 6A of IT Act is unconstitutional. In an attempt to acquire the sensitive information such as username, password or a credit card details is considered as a phishing. Phishing is attempt to take the information, secret information or a personal information. Authentication to be affected by the use of an asymmetric crypto system or a hash function is known as a digital signature. Cyber terrorism under the section 66F shall be punishable with imprisonment which may extend to imprisonment for life. 66A was invalidated in case of a Shreya Singhal. Which section of the IT Act 2008 amendment deals with the validity of the contracts through electronic means? Section 10A deals with the electronic agreements or contracts. Which chapter of the cyber law provides the legal recognition to the digital? Chapter 3 provides the legal recognition for the digital signature. Which act is covering cyber crimes? Information Technological Act. IT Act originally enacted in 2000. There was an amendment in 2008. Government of India passed the act with the objective to provide the legal sanction to all e-commerce, facilitate electronic filing, amendment Indian Penal Code and Indian Act to punish cyber crimes. All of these are reasons for the, or some of the basis for the IT Act 2000. Chairperson of the Cyber Appellate Tribunal is appointed by the central government in consultation with the Chief Justice of India. Controller of certifying authorities in India must maintain the database of the disclosure regarding the certifying authority and cross-certifying authority. Under Section 37 of the IT Act, the certifying authority can suspend the digital signature certificate if subscriber requests for the same or if it is in the public interest. In the cases before Cyber Appellate Tribunal, the appellant cannot authorize his relative or who is neither his officer nor legal practitioner to appear on his behalf. In India, which of the following authorities has the power to block websites? CERT-in is the authority to power the block. They can block the website if they are considered to be not in the public interest. Which among the following is authorized under the IT Act for the purpose of Section 14 and 15 of the Act with prescription on security procedures? Central government is authorized. Which reference to cyber crime? Worm attack, it does not need to host the attack. An attempt to acquire the sensitive information is called phishing. Asymmetric crypto system is a public key to verify the digital signature. Asymmetric crypto system is a public key to verify the digital signature. Section 43A of the IT Act deals with the compensation for the failure to protect the data. 43A for compensation of the failure to protect the data. Section 3 of the IT Act was originally digital signature, now renamed in Amendment 2008 digital signature and electronic signature. Which of the following are digital signature certifying authority? Mrs. SafeScript. SafeScript is the authority for the digital signature. Section 43 of the Information Technology deals with the civil liability. Section 43, civil liabilities. The questions related to the intellectual properties. The WIPO means World Intellectual Property Organization. Company wishes to ensure that no one else can use their logo is called trademark. Under Patents Act, which of the following are not patentable? A method of agricultural a presentation of the information or a topography of the integrated circuits cannot be taken as a patented. WIPO has replaced the pre-existent BIRPI. Before that, it was a BIRPI. Which of the following is infringement of the Trademark Act? Use of a mark identical to the trademark, advertising the trademark such as advertisement is against the reputation, use of the trademark as a business name without authorization, or infringement under the Trademark Act. Which of the following is wrong in respect of the copyright law? There is no copyright in government work. All the government work can be used by the public for the reference or any other purpose. Intellectual Property Appellate Board is established under the Trademark Act 1999. Which is the subject matter of the neighboring rights pretension? Performance is the neighboring rights pretension. Section 21ZB of the Trademark Act deals with the defense of the trademark. Which is not included in the meaning of the artistic work under the copyright. It's a work of a carpenter is not included in the copyright, whereas drawing, architecture, craftsmanship is included. Which condition is not required to be satisfied by an innovation to be patentable subject under the Patents Act? Distinctiveness is not included. Mainly it is the novelty, innovation and usefulness are included in the Patent Act. Two questions expected from the Land Acquisition Act. Let us go through the previous questions. Who appoints the Commissioner for the Rehabilitation and Resettlement Act under the LARR Act? State government appoints the Commissioner. In case of a land acquisition by the central government for the private-public partnership projects, the consent of 70% affected families is mandated. 70% is mandated. Under the Land Acquisition Act, the expression land means benefits arise out of the land, things attached to the earth, things permanently fastened to anything attached to the earth. All these are called land. Temporary occupation of a waste or arable land procedure when differences as to compensation exist is provided under the section 35 of the Land Acquisition Act. Land Acquisition Act 1894 came into the existence on first day of the March 1894. It is now revised after post-independence. It is also revised. Friends, these are all the important questions that we can think of. There are some questions with respect to the jurisprudence also. Which of the following statement is true regarding the characteristics of the international law? It has a formal law enforcing the agents. Republic Act 6770. Which of the powers is not provided for the ombudsman? Function to adopt, institute, implement preventive measures is not provided, whereas it is a prosecutorial power, public assistant functions. State practice of the formation of the customary is state actions as well as the state claims. According to one of the theories of the punishment, evil should be returned by evil. This theory is called the retributive theory. Ledroit des Gens, Law of Nations 1758 was written by the Emerkwidi Vattel. Law is considered as a form of the power values by Laswell R. McDowell. The development of the tradition of the natural justice in one of the natural law is strikes. Strikes is the development of the traditional and national justice into the natural law. Dono More Committee on a Minister of Powers 1932 is related to the UK. Who authored the book The First Principles of the Jurisprudence? That is a Salmond. Mare Liberum, the first published in 1969, is a book on Hugo Grotius. The book is written by the Hugo Grotius. Indian who presently member of the International Court of the Justice is the Justice Bhandari. International Criminal Court is based on the Rome Statute of the International Criminal Court. Constitutive and declarative theories are related to the state recognition. Tabula rasa under international law relate to the state succession. Tabula rasa is for the state succession. Who was the founder of the analytical scale? John Austin is considered the father of the English analytical school. Jural correlative immunity is the disability. Who defines the eternal law as the divine order of the will of the God, requires the preservation of the natural order, forbids the breach of it? Augustine said the same. Government, even if it is the best state, is but necessary evil in its worst state is intolerable. Thomas Paine said about this. Identify the correct order in which follow the law-making treaties are concluded. Vienna Convention, General Agreement on Trade and Tariff, Declaration of Paris. The first one is the General Agreement on Trade and Tariff, then the Vienna Convention, then the Declaration of the Paris are in the order on which the events took place. Which one of the following doctrine requires the parties to a treaty are bound to observe the terms in good faith? The Drago Doctrine. General Assembly adopted the definition of the aggression. None of these above are applicable. Anyway, admission to the new political entity into the United Nations is a collective recognition. A state is and becomes international person through recognition only and exclusively. Who stated? Oppenheim. Oppenheim is considered the father or a founder of the international law. UNICITRAL adopted the model on a Arbitration and Dispute Resolution Act 1996 Act. Fuller-Hart debate was related to the natural law and positivism. It is also between the law and morality. Fuller and Hart debate. Act of the court cannot do no wrong to any person. This is for the restitution concept. Blackstone defined the crime as a violation of the public rights, duties due to which whole community is considered as a community. Etymology, which is meant in the jurisprudence, is called the knowledge of the law. What is meant by the term general law? General law it consists of the general ordinary land of law. It consists of the legal rules which are taken by the judicial court. According to the theory of the social utilitarian is propounded by Jaring, the law means it is a social end. It is a means to the social end. Natural law, that is, there are rational objective limits to the power of the legislative rules. Hart's name is associated with the concept of the law. Second principle of the rule of the law is an equality before the law. AIBE talks about the rule of the law. He first kind. Who categorized the subject of the jurisprudence as expository jurisprudence and censorial jurisprudence? Bentham classified the jurisprudence as expositorial and censorial. Who described the jurisprudence as a lawyer's extravagance? Lawyer's extraversion. Julius Stone described the jurisprudence as a lawyer's extraversion. Fiction theory is related to the legal personality. Friends, these are all the questions which I have tried to cover based on the last 10 AIBE previous examination questions. And once you go through these videos, I feel you can comfortably get 40 to 50% of the marks. The coverage is very better. We have covered maximum possible questions. I have also skipped some of the questions which I consider either repeated or not important. With this, I am concluding this AIBE video sessions, and I request all of you to share this information to those who are writing the exam, and also like and subscribe if you like it. And thank you very much. I hope this will be beneficial to all who are appearing for the AIBE 17th exam on 5th February. I wish you all the best to all of those who are writing the exam. Thank you very much.